We have an interesting program. We have an interesting, very interesting first session. And I'll just hand over now to the chair, to the moderator of the session. The chair is Richard Hooper, a long friend of the ISC, a former regulator, and now the chair of two different groupings active in our general area of interest. One is the Broadband Stakeholders Group, and the other one, quite different, is the Copyright Hub. So with this, with your great experience, we are in your hands, and I'll hand over to you, Richard.
Thank you, Fabio. Grüß Gott, guten Morgen. If you thought yesterday competition investment ex-ante regulation ex-post was a hot topic, you've seen nothing yet. This is data protection, surveillance, cybersecurity, freedom of the press. I think it's useful at the beginning to just make one distinction between what I call state surveillance and corporate surveillance. Now, by state surveillance, I mean people like GCHQ in the UK, the NSA in America. Fundamentally, they're interested in finding, one hopes, a relatively few people, the bad guys. Corporate surveillance, which is the websites you use, obviously people like Google, they're interested in everybody. They're interested in all the people who use the website because they want to find out as much as possible about those people in order to target their advertising, because whether we like it or not, the modern internet is monetized by advertising. And as you well know, the more targeted the advertising is, the better. So state surveillance and corporate surveillance, fundamentally different. Now, we have a very interesting program, and the way it's going to work is we have a keynote speaker who will speak for no more than 20 minutes. We then have 4 excellent panelists who will speak for no more than 10 minutes, and they have all been warned. I get terribly upset if people go beyond their time, so I don't think that will happen. The reason is we want to have a good half an hour, if not more, for questions, comments, thoughts from the floor, because the IIC prides itself on being interactive. So could I therefore welcome our keynote speaker, Dunja Mijatovic, from the Organization for Security and Cooperation in Europe, and she's the representative on freedom of the media.
Thank you very much, Chairman. Ladies and gentlemen, good morning. It's a real honor and pleasure to have the opportunity to address you today and to talk about the issues that are extremely important for our societies globally. I hope that the discussion taking place are fruitful and increase the openness and plurality of communication networks and platforms. I'll stick to 20 minutes, even less than that. I'll try to behave. The topics and the questions for the first morning session are really impressive. And I honestly can only look forward to listening to the qualified opinions of the speakers. As you may imagine, but I'll try to be very brief in explaining the role I have in the Organization for Security and Cooperation. I will not be able to give answers to many of the questions that are posed before this panel in order for all of us to engage in a discussion that is so important nowadays. And that is because I wear a hat of the representative on freedom of the media of the OSCE, which is the organization not known to regulators, to people coming from the technical world, but is quite known in the parts of the world where we have troubles and problems like Ukraine at the moment. For me, it's also particularly interesting and important that I talk about the issues related to human rights because I come from the regulatory world. I built my career as a regulator in Bosnia and Herzegovina, which is my home country. I'm from Sarajevo. Later on, I was honored to chair a European platform of regulatory authorities in almost 2 mandates. The second one I had to cut short because of this new position I was given, which is in a way entering a different world from a different door. I'm also glad to see a colleague of mine, Michael O'Keefe, who was also chairing European platform of regulators, which is this organization that is so dear to me. But what I do now is quite far away from this kind of regulation. In a way, starting this job in 2010 was a wake-up call for me. Being a regulator, looking at development, technology, all these things that are so important, bringing people together, information travels so fast, access to internet, all these things are so important for all of us. But in a way, I think we are forgetting about human rights more and more because of developments, because of all these things that are, again, I'm not saying they are not important, but sometimes I think we live in a bubble and we are trying to divide things that cannot be divided. They have to come together. The organization that I work for now is an organization, as I said, for security and cooperation, where we have a basket that is looking at the security in our states. But at the same time, there is a basket that I represent, which is called Human Dimension, where we have the Office of the Representative on Freedom of the Media, where I try to see the issues of security firmly connected to human rights and freedom of expression, free flow of information, and access to information. Because it is my firm belief that we cannot talk about security if we do not respect human rights. And at the same time, I do not think we can say that we live in a society where we can freely express ourselves if we are not secure. So how to bring those two together and how to try to breach the gap that is very present and very existing in our societies. Liberty is the most precious right that we have in our societies, and we should not forget this. Without the freedom to determine for ourselves, we could be nothing but slaves. This, of course, includes the right to speak freely and the right to live privately with undue surveillance. As Cornelius Castoriadis said, democracy is the sole regime that takes risk, that faces openly the possibility of its self-destruction. Living in a democratic society means to accept the possibility of listening to opinions that offend and disturb, and to live with people we do not share our values, and to protect the dissemination of the most outrageous points of view. Moreover, democracy is supposed to be the most advanced and free system for common life, which means in the same time that it is exposed to the highest level of scrutiny and criticism. It is a kind of paradox. The most perfect democracy is the one that shows more openly its flaws. And what we are facing, as we say here in Vienna, because the office I represent is based here, we say east and west of Vienna we have problems, meaning that we have problems in so-called old democracies, but we also have problems in the new emerging democracies. And all this is created with a development, which in a way I do not think we are dealing in a proper way as experts, as people covering different issues that are important for every single human being. The threats we face today seem to be particularly different than the threats before. Security challenges are global and probably most catastrophic than ever. The world is less stable and predictable. We must acknowledge that we are probably looking for more security than it is attainable. Therefore, effective and proportionate laws to deal with security issues are unfortunately needed in most, if not all, OSCE participating states, and there are 57, and beyond. However, governments and societies should be aware of the fact that there is nothing which might justify the erosion of certain basic principles and rights which form the bedrock of modern democracies. And we heard here about the different surveillance, state surveillance and company surveillance. I do not in any way try to challenge the legitimate right of any government to fight our threats that we have in our societies, offline and online, not just terrorism, but child abuse, trafficking, and all these threats that, in a way, we have to fight internationally. But what I see as the OSCE representative on freedom of the media, that security reasons are used not really most of the time to protect us, but to suppress and to restrict critical voices. The voices that we do not like, differing, controversial, provocative, people touching the issues of dogmas and taboos in the society. And in this process, we see many companies indirectly helping governments target these people. And here I'm not talking about numbers or some analysis, I'm talking about real people that I met in many states, not only as free citizens, but in prisons, being detained, being threatened, and surveillance is most of the time used in order to track these people. To make things more difficult, the exercise of democratic rights online, including freedom of expression and freedom of the media, mostly depends on the decision made by private networks owners and service providers. Big portals, search engines, and technology manufacturers directly intervene in circulation, distribution, and access to content and ideas in new platforms. They have become the main gatekeepers of the digital world. In many cases, the effectiveness of the so-called internet freedom will be in their hands. I am fully aware that intermediaries in many cases have to follow orders and directives which come from state authorities. For this reason, the privileges and responsibilities of the different players need to be clarified. Excessive focus on intermediaries' liabilities can lead to private overregulation of content and undue and non-transparent restrictions of online rights, which we are facing in many parts of the world. Just think of many laws that many countries are trying to introduce for different reasons. No consultations, hasty decisions overnight, and everything in the name of security. Let me now take you through other main areas of concern which are directly related to today's topics of discussion, and I'll stick to time. Media have difficulties in reporting about surveillance and abuses on human rights due to expanding secrecy laws. Transparency and accountability is being reduced. Journalists face serious difficulties in gathering information, not to talk about prosecution of whistleblowers. New anti-terrorist laws criminalize almost all disclosure of classified information, including non-sensitive documents on issues of public interest. In some cases, anti-terrorist legislation has been misapplied and abused in order to hinder the work of journalists and suppress free media. I intervened in so many cases lately, in the past 2 years, on numerous occasions. I will not mention the cases, but later on, if there is an interest, I will of course go into details. The right not to disclose sources is, as well as we all know, a cornerstone of the protection of investigative journalism. And this is, in the work I'm doing, almost sacred. In several countries of the OSCE region, we have witnessed negative consequences. And we have also seen overbearing surveillance of journalists and their sources. Some of these cases, for example, one in the Netherlands recently, has been condemned by the European Court of Human Rights, which is a good development because we are already creating a case law that is targeting these very bad decisions. 1 year ago, most of us were appalled by the revelation of mass surveillance of individuals by intelligence agencies of several countries. Revelations about specific surveillance of journalists cause a major concern as well. Attacking the watchdog of democracy by tracking journalistic activities, discovering their sources and trying to know what they know is a step toward a totalitarian regime and cannot be justified on any grounds. And this is my firm belief and a message to most of the governments that I'm visiting and talking to when I'm raising the cases of people being targeted and journalists and media workers being targeted because of these issues. I also see many countries considering new laws to fight violent extremism. My office recently, 2 days ago, issued a communique on how to deal with anti-extremism law, and I will invite you to follow our Twitter and Facebook page, where you can find all these documents that are very much different from the work that most of people here are doing, but at the same time I think it's extremely important. Again, not to forget about human rights. Calls for genocide and hate speech targeting minorities is another problem that we are facing. However, it should not be forgotten that controversial words are best fought with more factual, reasonable speech and not by repression. I come from a very troubled part of the world, and what I noticed and what I experienced is that repression and restriction creates reaction. No matter how much you try to take the rights from people, it will haunt you. They will search for their right to gain their right back, to gain what they were not having because of certain movements by the governments. The challenges that we are currently facing cannot justify a permanent state of emergency or the arbitrary and impunity of public authorities, which is another problem. The fight against terrorism and violent extremism will only be effective and successful if we keep our precious principles and values in the course of the battle. Otherwise, those who will win will be the enemies of our freedoms. And this is what we should fight against. Otherwise, we will go back to the dark societies. I know this sounds very pessimistic, and it's not something that people like to hear on a day when they want to discuss also issues of the developments, but we should never forget about the importance of human rights, even when we discuss issues, as we call them, of technical nature. Thank you very much.
Thank you, Johnny. Thank you very much, Dunya. Could we then move to our four panelists and start on the west coast of America, well, from the west coast of America, the staff attorney for the Electronic Frontier Foundation, Hani Fakouri. Hani. If you want to, or sit here. Sure.
Oh, this is fine. Well, thank you very much for having me. I've got 10 minutes. I'm going to try and do it quickly. And thank you very much for having me. Just to kind of lay out what the Electronic Frontier Foundation is. We are a civil liberties nonprofit organization based in San Francisco in the United States. And we focus on surveillance and technology issues with a particular emphasis on service providers. We've both consulted and advised some of the large service providers like Google and Facebook. We have directly represented some of the small service providers in legal battles and legal challenges over surveillance. In fact, me being here today is kind of perfect timing because just yesterday a case that we've been handling in the U.S. courts about a service provider, a very small service provider that brought a legal challenge to the FBI's use of national security letters, which is a form of surveillance where the government, the U.S. government, can get certain records from a service provider without any judicial oversight at all, simply by issuing a letter, and it comes with a gag. And we were able to convince the lower court that the statute was unconstitutional, and that's up for battle up in the Court of Appeals, and that was just argued yesterday as I was traveling to Vienna. So that's a little bit about the work we do, and it's perfect that I'm here today to talk to you folks a little bit about that. Obviously, this is the panel on human rights and on how to conduct surveillance consistent with human rights, or how to, comply with the obligations of assisting the state in combating terrorism in a way that's consistent with human rights principles. Oftentimes, we talk about human rights in an abstract sort of way. We talk about some very, important and fundamental rights of privacy, of freedom of speech, freedom of expression, freedom of association. But when it comes to dealing with obligations imposed by the state in terms of complying with surveillance requests, or when it comes to designing a company's architecture or securing the data it's storing on behalf of its users, what does that mean in the practical real world? We all want to respect human rights, but how do we actually do that when it comes to the service provider and the state and the relationship between the two? And so in my time, what I want to do is give a suggestion on how that can be done. And that's by specific reference to a set of principles that the EFF, along with a broad coalition of groups from many other countries around the world, in fact, over 400 different organizations from over 150 different countries, have worked together to kind of show a kind of a path forward in terms of how to reconcile human rights with surveillance law. And this kind of road work, it's called the 13 principles, of how to conduct surveillance consistent with human rights principles. These 13 principles, and I don't have the time to go through all of them, but you should definitely you could check them out on the web at necessaryandproportionate.org. These 13 principles provide a roadmap, a guide to how both the state can conduct surveillance in a way that respects human rights, and at the same time shows to service providers and regulators what is an appropriate surveillance request and what is an inappropriate surveillance request. And obviously, again, all of this is kind of informed in part by the mistakes that countries have made. I think most predominantly the United States, the mistakes that the United States has made in conducting its surveillance activities, particularly after the terrorist attacks on 9/11. But it's not just a response to U.S.-based mistakes. In fact, this effort to put together these 13 principles began before the Snowden revelations. And only after the Snowden revelations has just reinforced the need to have these kind of principles, this pathway for service providers and for state regulators and state actors to keep their citizens safe, to safeguard against terrorism, but do it in a way that is consistent with human rights principles. I mentioned that it's been signed by over 400 organizations in over 150 different countries. It's been cited in the IACHR's annual report, in the U.S. President Barack Obama's review group on intelligence, as well as UN reports on freedom of expression that were written by the UN Special Rapporteur on freedom of expression. And it specifically draws on some of the foundational documents that regulate what human rights mean in the modern age, including the European Convention on Human Rights as well. So what are these 13 principles, and what is the way to think about how to conduct surveillance in a way that treats human rights as an important principle to be respected in terms of conducting this type of surveillance? Well, the real bedrock, the real kind of foundation of these principles are four principles that I'm going to group together for purposes of discussion right now, which are necessity, adequacy, proportionality, and transparency. And while these all sound self-explanatory, and while they all sound, important, we have seen a stunning lack of all of these things when it comes to the way surveillance is conducted, particularly in the internet age, where companies can store such massive amounts of information and data about their customers and their users, and that data becomes a landmine, a treasure trove filled with useful bits of information that the government wants to review. So what the principles say is that it starts at a foundational point of recognizing that surveillance is an extremely intrusive act that infringes upon these fundamental human rights, like privacy and freedom of speech and freedom of expression, and increasingly security. The idea that our data should be safeguarded and our communications and our personal data should be protected. And so instead what the principles say is that surveillance should be narrowly tailored and only appropriate in compelling circumstances, when absolutely necessary for the government to solve a crime or prevent a terrorist attack. At the same time, that is very focused on the government, but there's still a role to be played by the providers as well. And the providers have a role to play in making sure that they're minimizing the types of data they're keeping on their customers, that they're collecting only what they absolutely need to collect or only at the boundaries of what the law requires them to collect. When it comes to transparency, there's a great need for government transparency in surveillance requests, but there's also a lot of room for the service providers to be transparent, both to the specific user who is affected by a surveillance request, as well as to the general public in terms of publishing transparency reports where companies can detail, the number of requests they obtained, the particular reasons for the request, who the requesting agency was, the amount of time the request was for. Was it an intercept for 30 days, 45 days? All of this matters in giving the public an informed understanding of what their data is, of when their data is likely to be disclosed, who is likely to receive it, and allows customers to make a choice on where to store their data and keep their data, and not only that, but what information to keep with certain companies. Another fundamental part of the principles is the idea that there should be an integrity to communication systems. That is the idea that it is not the service provider's responsibility to provide an inroads in for the state. So if the company wants to create a backdoor of access for the government, they have to understand that that backdoor is also going to be exploited by malicious actors as well. You can't create a government-only backdoor. A backdoor is a backdoor, period. And so we should be discouraging those attempts. In fact, instead, we should be encouraging companies and encouraging service providers to safeguard and beef up their privacy protections. To give an example from the United States very quickly, recently, Apple introduced new iPhones and introduced an upgrade to their operating system, iOS 8. And within that upgrade, Apple announced that it was changing the way it was doing the encryption on the actual Apple device itself, your brand new iPhone. And it said that no longer would it be able to unlock the device at the request of law enforcement. And in fact, it was basically going to make it impossible for Apple itself to be able to access a device that had been encrypted and locked by the specific user. Now, for the privacy advocates like myself, this was very good news. But understandably, in the United States, there's been a great deal of hysteria about it amongst law enforcement agencies. The director of the FBI, the Attorney General of the United States have come out and said this is a terrible idea. All the pedophiles in the world are going to start using iPhones. And I said, well, everybody already uses an iPhone anyway, so I don't see how this is a big problem. But this is the kind of demonstration of how we see the state undermining the integrity of the communication system. Now, for a company like Apple, which is a large company, it has a ton of money, it can perhaps withstand that government pressure. But there are going to be smaller companies that are not going to be able to do that. And so it's important that as states, as service providers, as we're coming together to talk about these issues, that we work together to collaboratively, think about ways to keep our communication systems, really filled with integrity and secure. I think my time is up, so I'm going to leave it there because I can see the stairs, and I'm happy to look, and I'm really looking forward to having a further discussion on this. And thank you very much.
Hanny, thanks very much. Come and next to Julia. Thank you very much, Marco. It's highly appropriate that our last panelist comes from Austria and also comes from a mobile operator. So willkommen and Herr Dr. Klaus Steinmaurer.
So, hello everybody. Thank you for being invited to bring in my comments on this conference today. Just to introduce myself, my name is Klaus Steinmaurer. I'm head of the Legal Regulatory Department at T-Mobile Austria. This department is also responsible for the legal interception in Austria for our company, and I'm in this business for a very long time because I came in the Austrian telecommunication market when liberalization started in 1996, so at the very early part. Therefore, I had also the possibility to have some influence on the development, how we work in these questions concerning interception. But coming back to that, when Richard started, he said, okay, today we are discussing about questions about state surveillance and company surveillance. That's interesting, but we should also take the question, are we talking also about state responsibility and company responsibility? And so I try now to introduce a bit the view of the operators' view on that, network operators' view. So just for short, coming back also to what Dunja said, it's data security, secrecy of correspondence, secrecy of telecommunications are human rights. They are questions of constitutions. All democratic constitutions, they are secured. So therefore, that's the basic for all the services offered to the customers. And now we are coming to something what brings us as an operator a bit in a sandwich position between state operators like Google and as a pure network operator, because you are, Marco, you are selling services for data, we are selling access for money. So therefore that's the difference. Therefore I'm convinced as a network operator we have a bit more responsibility and a bit more have a deeper look on the data people are giving to us, especially regarding the data the state is wanting from us in several cases. So therefore, from my point of view, in our business, constitutional right comes first. It means data can only be given to the state or others if there are exemptions by law, and sometimes there's a conflict between the human rights guaranteed, like right of freedom, right of security, and so on, are conflicting with the right of secrecy of telecommunications. So therefore, here the exemptions can be placed. These exemptions must be defined by law, and that's what also Ian said. For the intelligence services, there's a law differing in the countries. We have a clear statement that only an attorney is allowed to tell us that we have to give out the data to the state. I don't want to get deep in that. So what we can say in developed democratic countries for operators, it's for sure that only if there's a clear, transparent legal ruling, you can use the data for state interests, and you are not allowed to use data. It's a huge bunch of data you have as an operator. You know where the people are and what they are doing and how they are driving through the country. It's interesting data, but you're not allowed to use this data for commercial issues. So that's, for me as an operator, a clear thing. Only if there's a clear agreement with the customer on that. So therefore, as Ian said, so it's not for free that as an operator you think you can make deals with Starbucks and McDonald's, just you can send add-ons to your customers. So it's, from my point of view, not fitting to the responsibility. Therefore, coming to company responsibility, for the responsibility operators have to follow. And that also comes to the main point that operators then are in a sandwich position. They have many data, but they can't use it like Google to monetize it. So what is the future business model of operators? If they can't use their data to make money out of them, and on the other hand, the prices and the revenues are going down because the access isn't worth that much for the people, so people are not paying. So what might be the future business models for operators in this surrounding? So at the end, I can tell you the business model of operators in this kind will be and must be to focus on trust, because trust in the operator is one of the main points why people are making a contract with me, why people must and can feel secure that their data, what they are doing during the day, will not go out to everybody for commercial reasons, for intelligence reasons, and so on, only under certain circumstances. So we have to support the state. That's clear, but only under transparent and clear rules. So that's, I think also what Dunja said, there must be clear and transparent rules when it's possible, and it should not be, as it's a bit the development now, just making under security reasons any law we think it's needed, not asking the people and not making looking at the balance on that. And so therefore not what's technical possible, but what's legally allowed is at the end the question. And we as an operator have to balance on that. And I also see it from my personal work I'm doing here in Austria for this time in this issue. As an operator, to build up this trust to the people, you have really to involve you in the discussion, the legal discussion around which data should be made public to the state, or either made public to the commercial companies. We have to involve us. We have to really take a clear look on that, and we have to try to keep it as to make really a very short and very small kind of data being stored on that. That's I think also Hani said in his, just keep it on a very low level. And therefore, for that, security and privacy will be the operator's business model for the future. But nevertheless, as we have the technical developments to face, like what's going on, and what you personally also know, you are giving your data for free to all of the world. Yesterday, 2 days ago, I read in the newspaper in Austria that in New York, young artists gave cookies to people, and people were asked they have to pay these cookies for with their data, and they gave everything for that. That's like what you said. Okay, people also give their firstborn children for having access or for getting data. So therefore, people don't know what they are really offering to the companies, and that's for me one point I want to address at least, and it's important also for us as operators, also in the reason that we can build up a good business model in compared to operators like Google or Facebook or something like that, is that we have to really work on a new kind of data protection. From my personal view, the actual development we have in Europe, the Grundverordnung, I don't know, it's the general new ruling on Europe, is not really the revolution we need. It's a more evolution of the old. But we have now a new industry, a new business, and so therefore we need something new also here, which gives the possibility to hit all the surveillances we are talking about. So therefore, thank you, and have a good discussion.
Thank you very much, Klaus. I think I'm going to stand up here. There's a group of people there that can't see the speakers, because this hides them. If you want to move here, there are lots of free seats in the middle, because we've got 45 minutes for discussion, and I want you to be able to eyeball these people. Can I suggest, do come and sit in the middle here, honestly, because I know you can't see always. What I suggest we do, we've got 45 minutes for questions and comments. Let's start by having questions and comments about state surveillance, and put young Dr. Levy on the spot. And then move to company and corporate surveillance, because I think that's the easiest way. So who's going to ask the first question or make the first comment? And we've got microphones. Right, first one over there. Thank you very much. Please say who you are, where you're from.
Thank you. I'm Megan Richards. I'm from the European Commission, but I'm speaking in my personal capacity now, and I have a question for Dr. Levy. And it relates relates primarily to the presence of closed-circuit television in the UK in particular. And you rightly identified the problems with identification of personal data on internet-based systems. But my understanding is that the CCTV network in the UK, which is everywhere, is more or less accepted by citizens. So I wondered if you could comment on that apparent conflict between what seems to be accepted in one context and perhaps not in another.
So I'm not 100% sure about the CCTV network in the UK, because there isn't one, there are lots. And they're governed by various laws depending on what they are. So if you look at the one around London, the main one there is a number plate recognition system for congestion charging. And there is an absolute call out that the only thing it is used for is congestion charging. Cannot be used for anything else. The private CCTV systems are covered by all sorts of things like the Data Protection Act. Government CCTV systems, where they exist, also Data Protection Act. So I don't think there is an invasive, ubiquitous identification system in the UK using CCTV. And if you think about scale, it's scale that makes anonymization difficult. So having CCTV cameras doesn't scale. You know, they're physical things and you need to get power to them, and they're expensive and you have to monitor them and actually infer from them. And so generally speaking, you use people to infer from video images. It's very difficult to get a computer to do anything more complicated than number plate recognition. If you look on the internet, the data you get is much, much richer. And so I think the potential for intrusion on internet-generated data is very, very much more than things like CCTV.
Marco, do you want to?
Yes, on this I really feel compelled to make a comment, because I think it's, especially in the European environment, it's wrong to think that the laws are applicable only to the offline environment and not to the online environment. You made before the example of a company that is collecting data in relation to the health of their user, because they have a device and they want to track how many hours they are sleeping, or how many hours they are walking, or the physical exercise that they are doing. Let's assume that this company based in France or in US or in Canada, anywhere in the world, is communicating this data to an insurance company or to any other subject which is not included in the privacy policy that the user has signed, or even if it's included in the privacy policy that the user has signed, is not in line with the European privacy law. This would be illegal. This would be illegal, as much as collecting CCTV data about user for trafficking reason and then using them to detect if somebody was robbing a bank.
Absolutely agree with you. Sorry, I absolutely agree with you. The difference is that I can push around lots of anonymized data sets on the internet. They're generated by everyday use. And those anonymized data sets are moved around, and they are not generally covered by data protection laws because they're anonymous. They're not uniquely identifiable. The challenge is when you bring lots of those together, there is lots of public research that says you can de-anonymize some of those data sets. And that's where I think we're going to go, and we need to just be much more careful about how we do that in the future.
Megan, are you happy with that answer? Okay, question here. Thank you.
Peter Lovelock, TRPC. So thank you very much for the presentation. Again, question for Dr. Levy. You dropped a bombshell, I think, with the line that mass population anonymization is probably out of reach, if not impossible. And I'd be fascinated to hear more on that, because mathematically that's my understanding right now, and yet there's a lot commercially, if not from a state national security perspective, staked on the fact we believe anonymization or pseudo-anonymization is possible. There's a lot going into that. Question one. Question two, with what we can do with anonymized data sets and the amount of information that is out there, how much better are the security agencies getting at mining that data right now? Because the old profiling techniques have been discredited extraordinarily. So how much better at mining it are you getting?
Ian, and then some of the others perhaps. And Dunya might want to come in on this.
So I think the population scale, multiple data sets problem is a genuinely interesting current research topic. So we're interested for lots of reasons. One is the UK government has got a piece of research going to see if we can do a census without doing a census. So can we do a statistically valid census without sending a questionnaire to everybody by using the administrative data sets that government holds? And how you do that without generating a massive database that uniquely identifies everybody in the UK and all the profiles that you have about them is really, really difficult. And we're actively doing research to try and enable that to happen so that I can give people guarantees that when this happens, it's this much work to de-anonymize them and give them actual information. There's a government open data push, and so we have data.gov.uk, which is freely available. Data sets are put up there. At the moment, there's 19,500 different data sets. And so what are we doing to try and make sure that that doesn't become de-anonymizable? Well, we're doing lots of work at the moment, but it's getting much more difficult. And so those two things by themselves have pushed us to put some research out to both academia and industry about trying to do new techniques for doing anonymization, or more importantly, understanding the cost of de-anonymization. So if we can give people guarantees about it's this much work, you have to use this much compute to de-anonymize a data set that's protected like this, you can start to have a conversation with people. But as far as I know, it's an open research problem everywhere. As I say, we've put unclassified research calls out to academia and industry. On the second question, so profiling was shown to be bad. A different sort of profiling works really well. So if I draw an analogy with internet advertising, so if I like buying red shoes and I have a particular set of behaviors, activities, websites that I visit, etc., that statistically is linked to other people that like red shoes, over time, if you can take that and say, well, therefore, it is statistically more likely that someone with that profile always likes red shoes. And that's an interesting thing to say. If you cross out red shoes and write involved in terrorist activities, you get the same thing. It's the same technology, just used for a different purpose.
Dunya, do you want to comment? Because, I mean, that's, as you say, a bombshell. I mean, we're told by all our service providers and operators, oh, don't worry, it's aggregated. You, Richard Hooper, or Andrea Millwood-Hargrave are not going to be noticed. It sounds like that's not going to happen. Dunya, comments?
Briefly, what Ian said is actually a key answer, guarantees to people, and who will offer these guarantees. What we need to look at is, it's not very diplomatic to say this, but I have to say it, which government is offering these guarantees? Is this a government that is known for respecting democracies, or it's the government trying to track people for different reasons? So how to come together in this and how to offer these guarantees, and not to mention that everything that is done, for example, in the UK, in relation to these issues is copied in many parts of the world. And if the UK is doing wrong things, there are also countries using this as an example to continue guaranteeing people, but what the guarantee means is actually accessing data in order to prosecute those people. So it's a double-edged sword, and in this process it's extremely important to find a balance. What I always say, I'm quite allergic to balance, but we need to find a way in order to offer more transparency in this process. Otherwise, I mean, we are already in trouble because the world is changing so quickly. But we need to do more in order to have more understanding on how to protect citizens.
Hani or Klaus or Marco? Hani, I can't imagine you haven't got a view on this.
Just one thing I want to add.
Klaus? Yeah, no, do.
Sorry. Okay. Adam, that you say, we don't know who guarantees it, who can guarantee it. So personally, I think it's only the state or the government can only give the framework of democratic level playing field. But this kind of guarantee, it's part of what the companies should really offer, and the consequence not giving you promise a guarantee and not really fulfill it. The consequence is that you lose your business. So therefore, I think it from an operator's view, and it's one of these things, we should dare to give such guarantees, and we should make transparent if there are developments outside which are damaging these guarantees, perhaps the state developments. So therefore, I think it will be the companies who can give those guarantees, and it will be the trust and the security guarantees which will be the operators' business models for the future. People will pay for that. That's my possible.
Hani, and then we'll come to another question.
Sure, I think that the problem of anonymization is a good argument for why the legal threshold for access has to be dramatically ratcheted up across the board, both in terms of domestic access or for national security access or whatnot, because the reality is that the metadata of yesterday, if you will, is no longer just metadata, right? It's like one discrete bit of information that in isolation wouldn't reveal much. Well, if you aggregate it with a whole bunch of other things, reveals, you know, I like red shoes and I like, you know, one football club versus a different football club or whatever. And now that reveals much more about me. And now we're starting to intrude into those kind of very sacred pieces of human rights, like privacy, like association, like expression. And so I think the reality is as the data sets become richer and more revealing, the legal standards for access have to go higher. It should become harder for the state to access that data. It should be harder for the companies and the service providers to turn that data over to the state. And you know, we can talk about ways to, you know, perhaps think about how the companies should be at least, you know, somewhat restrained in terms of what they do with that data for their own purposes, for business purposes. And I'm not really quite sure, and maybe people here may have other ideas about that, but again, the fact is that all of that is an argument for why the legal standards that currently exist under many countries' laws, including the U.S., are inadequate to deal with the realities of modern technology.
Just a little comment from Ian, and then back to you, and then to the next question.
Just really briefly, we're using the word guarantee to mean three different things, I think. So we're using it in one sense to mean the guarantees that people like Google give you and saying, you know, I will act like this as a company. And that's a guarantee that you get when you take their service. You're getting the guarantees of people like T-Mobile, who are constrained by law. Right? So you've got a civil guarantee, you've got a legal guarantee. The types of guarantees I'm talking about are where we say, look, I don't expect you to trust me anymore. I get that we have to hold ourselves to a higher standard. So, UK citizen, when we are doing the census work, here is the algorithm we will use. It's published. Have academics look at it. Have people look at it and kick it about and say, actually, yes, it works. Have ministers stand up and say, that's the only algorithm we'll use. And so you know how much work it is, because you don't have to trust me. Yeah? We've got other people independently to look at this, and we're doing this more and more. So we're doing it with smart meters in the UK. So smart meters potentially are hugely privacy invading, because they give away pattern of life information. One of the key principles about smart meters in GB is they are not. That's the principle. Principle number one is they do not invade privacy. And so, again, you don't have to trust me. Read the spec. It's public. Sorry, when the EU allows us to publish it in a month, it will be published, and everybody can read it and say, does it do what we say it does? And so we're trying to be much more transparent, not just in terms of legal orders, but also in terms of the wider stuff that we do about, look, we're not all evil, we promise.
Okay, Marco, briefly, then
yeah,
you... No, just Marco.
Very, very quickly, I totally agree with the EFF on the need to make the standard and the rule of law very, very strict in order to access to information. On the guarantee argument, I think it's very important to remember that there are different relationships here, and the relationship that there is between citizen and government, the relationship that there is between citizen and private companies is a completely different thing. While the first is regulated by the contract, the social contract between governments and citizens, and the accountability of the governments, where the citizen has a very important value for our living together. For what concerns the companies and the trust that we build with our user, the fact that we are in a very competitive market means that if we make a mistake, and taking aside that if we not respect the law, if we break the law, we should pay for it. But if we make a mistake in the trusted relationship with our user, we paid a very, very high price. So this is why we are really focusing a lot in order to make sure that things like transparency, accountability are on top of our agenda.
So I thought it was a quick follow-up question. Dr. Levy, I think you're spot on. It's where I was going to go. I think the use of the word guarantee is actually completely the wrong word. I think we're moving into a new trust regime. And I think you've, again, identified where the crux is, which is the cost involved around this whole equation. I thought you might have all gone there. So my follow-up question was actually going to be, how far off do you think we are from, it's the commercial question, so I think it's to Marco, but it's probably as much to Dr. Levy. How much do you think how far off from turning it around and the monetization aspect, the new business models, empowering me? So what we start seeing is people making it valuable for me to protect my data myself, and that those models start emerging, so that if I'm prepared to pay, it just becomes prohibitively costly to start attacking my data, and suddenly I can start working out who I want to have access to it.
Ian, Marco, and then I'm going to take that question over there. And then that one over there.
So I think that is a genuinely really interesting question, and I think it goes to internet governance more than anything else. So I think if you look at net neutrality, I can see a time in the future where people choose to either pay for service with data or pay for service with money. And that brings some net neutrality questions, because do I get the same service guarantees for both of those models? If I'm paying for stuff with money, I think, and I'll defer to Marco, I think the service I will get will be less valuable to me than if I pay with my data, because it can't do all this inference around me. So I get less of a service. There are lots of things coming around Internet of Things, where the Internet of Things protocols need better security, so that we can say, you know, I'm going to use a Bluetooth LE bearer of opportunity. I'll use any Bluetooth LE connection I can get to throw this chunk of data out to the service that's servicing my Fitbit, but I can tell myself it's encrypted, and only the Fitbit service can see that. That's where I think we're going to have to go, in that the services protect the data, because net neutrality and internet governance is going to keep us having the networks open as they should be.
Marco?
Very good question on the different business model that I think should live together. Advertising is a business model. Monetization through paid services is another business model, and I really think that there is no need for having only one business model online. So monetization actually for profession, for businesses is also the way we deal with our customer in the business environment. But on top of that, the security standard and the privacy standard for both the business model should be the same. So monetization should not be a way to provide more privacy to the user, but to simply provide a different, establishing a different relationship with the user, and therefore providing services which, for example, does not include any advertising. Just to make an example, because again, the business model is not an excuse to get data from user to use it in different contexts. Is just a way to make possible to provide services to the user.
Question over there.
Andy Korn from Bird & Bird. I think as a lawyer, but not only as a lawyer, most of the people here in the room have two hearts beating in their chest, because on the one hand, we're all somehow working in the ecosystem, trying to enable the use of data. On the other hand, we're all users ourselves and wonder what's happening with our data. I think, as an observation, anecdotally, if you like, there was a survey saying that the amount of information that is being given with respect to general terms and conditions and data privacy information reaches the length of short Shakespeare plays, which basically means that indeed nobody's going to read it, and we, as the ones that are trying to ensure compliance by this, actually only ensure compliance on paper. And nothing else. What is really happening with the data is actually something we do not know, and I also agree from my own practice that we have to say goodbye to the concept of anonymization. It does not exist anymore, and it will no longer exist, particularly when Internet of Things and machine-to-machine communication will continue to evolve and develop, because there's even more data around. Now, the question arising out of this, and this is what I'd like the panel to address, is what data protection, data privacy, and data security concepts do we need to look at for the future? Because it's very obvious that the loss of control over data comes more or less under the disguise of usefulness of all the applications that are being offered to me, including better insurance tariffs, for example. But is there something that we need to do in terms of privacy by design, for example? Do we have to ensure more data privacy from a technical perspective at the sources of where the data is being generated, and do that not at the cost of having requirements on the data security side that are so high that will render the business case completely impossible, which is actually being done in Germany as an example with regard to smart metering. If you have security requirements that are that high that you cannot pay for them anymore, you kill the business case and you actually kill something which is very useful with respect to the use of data. So the question really is, we need to have new concepts because our old data protection concepts do not seem to work anymore. What are those concepts?
Henny, do you want to have a go at that?
Yeah, I think there has to be both. There has to be both the technical fix, the privacy by design, the strong safeguards, and there has to be a legal fix too. So when it comes to the technical design, I would say it's less a matter of imposing, of the state imposing requirements on the provider to architect its system in a specific way, and more a matter of the state not telling the company to provide like a backdoor access, for example. So in the US, for example, we have a law called CALIA, which applies to telecommunications providers like T-Mobile, for example, and it requires them to make their telephone systems, their architecture to be configured so that the government can install an intercept or a wiretap. And that law only applies to telecommunications companies. It doesn't apply to internet service providers like Google. And so there's no requirement on a company like Google to configure its system that way. Now, there's a push to change that law to make it cover internet service providers, and we think that's globally a bad idea. So that's the type of approach I would say should come from that to me is the extent to which the state should meddle with the security aspect of it or the technical aspect of it. They should basically stay out of it. And it will be up to the companies then to impose safeguards to data in whatever way they see fit. Now, I think that in the last 18 months, we are seeing kind of a new paradigm where now all of a sudden privacy is a commodity, and it's something that the companies are increasingly taking seriously and are increasingly making a priority. So I mentioned, when I was speaking, I mentioned the Apple encryption. Well, you know, the day after the Apple encryption announcement, Google announced the same thing, and in fact, Google had actually already had that system in place in its Android phones for many years, but its change was that it was going to turn it on by default. So you're seeing already a little bit of a battle, and I think you're also seeing the rise of competing services that offer, you know, to sell you email without advertisements, or to sell you a secure phone that again puts the emphasis on privacy rather than some other feature. And there's going to be a marketplace for that. It's certainly going to be small to begin with, but perhaps it'll grow. In terms of the legal requirements, this is where I think you know, in addition to the idea of no mandates in terms of installing backdoors or undermining encryption, I think at the same time you also have to see states imposing strict requirements for law enforcement access to the data, meaning the best way to secure the data is to not allow the government to get access into the data unless it's absolutely necessary. And if it makes a showing that access into the data is absolutely necessary, then there should be some very, you know, strong safeguards in terms of what the state can do with that data once it gets it. So if it gets emails or phone calls or whatever it may be, there should be restrictions on how long they can keep it for, what they're supposed to do with it, how they notify the user that they took the data, what they can use it for. If there's a violation of the law, the data should be inadmissible in court proceedings. It should be purged. You should have a remedy. You know, the private person whose data has been seized improperly should have a private remedy against the state in order to, you know, deter it from engaging in further misconduct. So you need both. You need both of these things. And so, but I think in terms of the technical aspect, the most important thing is, you know, we have to keep the state out of meddling with security. I mean, obviously, if a company is being terrible about its security practices, there should be looking at, you know, there should be someone from the state looking at it. But what we're really talking about is we don't want the state to undermine security in the name of law enforcement or national security.
Klaus, Dunja, and then Marco, and perhaps Ian, and then we're going to take the next question.
Yeah, I agree what you said about the new concept and the need for a new concept in relation to this particular topic. The first reason, I think, it's not just, you know, it's time for it. I think there is an alarm clock ringing and actually warning us that we should engage in trying to offer something that would be more transparent and accountable to public. In many countries, laws have not kept with the technologies, and this is something that we keep forgetting. And they are leaving significant gaps in protections of all rights. And the second, in the absence of these, of the adequate enforcement, which is also missing, and oversight, just the mere existence of these laws is not going to help in this process. And there are widespread violations of laws relating to the surveillance, even in the most democratic countries, as we heard today. So in a way, we are tapping in a dark or just moving in some sort of gray zone. And in this process, for a good or for a bad reason, states are doing things that are affecting our rights. And I would agree that there is a need for a new concept, but including all stakeholders in this discussion, not leaving any side left without consultations.
Quickly, Klaus, Marco, and then Ian, and then we're coming
short. That's what I wanted to say at the end of my
microphone. Klaus, microphone.
Sorry, just one thing. That was one of the parts I wanted to say at the end. The actual data protection legislation is not adequate for the situation we have. We had a change in society which is still going on. So I agree with you that we should say a goodbye for anonymization in the way we have it now. It's also what should we focus on in the future if we have a new data protection concept. I would say we should focus on the data usage more than the actual concept we are looking at, which more on who is owning the data. So from my point of view, we have to divide first it's three layers a future data protection concept should have. There should be some data which is absolutely secure, which cannot be used for anything other. That must be guaranteed by law, so that the absolute security. Then the next layer is the privacy by design, where each customer should have the possibility, do I want to have it not open and public, or should it be public? So it's more an opt-in solution where the customer gets the possibility to decide, and everything else should be just for free, because that is a balance which says, on the one hand, the privacy is secured for the people and they can really influence that. On the other hand, business models are also secured, because it's naive to believe that in future data shouldn't be used for business reasons. So therefore, this should, from my point of view, this three-layer concept we should look at. And one thing below, there should be also some difference in the data produced, because personally I think it's a difference if people, if the business model is like yours, people pay with data for the service, or the other thing, people pay for the access and therefore they produce the data. So as an operator, this data I get shouldn't be allowed just for monetizing it, as I think. It's a bit, they have a higher security standard than those given to Googles or Facebooks or something like that. I think. That's personal view, so just...
Marco,
Yeah.
and then Ian, and then we're going to go to you.
Very quickly, on anonymization, I think we all watch CSI, so we know that nothing is impossible. But from there to say that anonymized data is a lost cause and all the data, whatever kind of key applied to anonymize them is useless, I think it's not correct. I think still that's a very important way to make sure that good use and an appropriate use of data is done. On the control of data is absolutely an important way for us to, as industry, to compete. And actually, we should compete more on control of the data. I don't think the competition, again, as I said, should be between a business model where users are buying services with data and a business model where users are buying services with money, because actually this will even not, I think, market the services of who has a different business model in a proper way. I think the business model is monetization versus advertising. Advertising is a very different and complex way to monetize. On the enforcement, I'm a lawyer as well. I was doing the profession before. I joined the internet industry, and I have to say that there is a lot of work for lawyers. Since look at a company like Google, we are dealing with 28 data protection authority across Europe. They are trying to enforce their law on us. They are actually enforcing their law on us. There are fines that are paid by companies like Google, and not only by Google. If you look, for example, on consumer protection, there was very recently a very important discussion that we started as an industry, Google, Apple, Amazon, with the Commission, in order to make sure that some clear standard of consumer protection are applied, and we were very happy to meet these standards, not only Europe, but globally. So this means that I really would like to go out from this kind of mood that we have always seen in panels that, important concept like anonymization is just possible and useless, control of data, forget about that, enforcement does not exist. These are things that in everyday life, internet companies are seeing as a reality and actually as important ways to conduct business.
Ian, very quickly.
I'll be very quick. So Marco, it might be inconvenient that multiple data sets break anonymization, but it's true. There are plenty of learned papers in learned journals over the last 10 years that prove that's the case. To the original question, so I'm not a lawyer, so thankfully I don't write laws, I just have to obey them. Personal opinion, and this is a very personal opinion, I think data protection, sort of extending what Klaus was saying, I think data protection has to come to impact. So as a person, as a user of these services, do I care that somebody has access to my data, or do I care that they have done something with it that has an impact on me? And whether that's the state or commerce doesn't really matter for this discussion. So I think we're going to have to be much more subtle about data protection in the future. I don't know what it looks like, though.
Now, we've got 10 more minutes. I've got the next question there, then I've got a question there, then I've got Cordell Robert, person in the front. So the rule is now just ask a panelist a question, don't ask the lot. And I promise you I won't spread it either. Question.
Thank you very much, Masawan Potogwane from Botswana. Very useful discussion here, and I'm very worried. I come from a country where we are pushing to have more access to broadband. And I think, to me, the analogy is like getting somebody from Austria and putting them into a national park in Botswana without any ground rules. So we are taking our population and putting them into a cyber jungle without cyber rules, cyber security. And I look at the names of these organizations, OSCE, EFF, and my question is to Google, probably the biggest user. What are you doing to help our societies, which are naively and gullibly taking on Google with the assumption that this is the breakthrough to modernization without realizing it's a cyber jungle where we don't know the rules and the threats, and we don't know the risks, and there's nobody responsible for us?
Marco.
Yes, we are making a lot of investment, especially in Africa, in order to foster access. We have done a great work in Kenya, for example, on way to bring access to these countries and to the area. In general, investing a lot of money. There is a representative of the Google policy team in Africa I can put you in touch with. Another project that I would like to mention is Loon, where we are actually partnering together with telcos in order to make sure that we can give access, internet access in rural areas, in areas that are very hard to reach with the networks, through balloons. We launch balloons in the atmosphere, and then through, thanks to the collaboration with the telcos, we give access to a specific area that is under these balloons. So there are actually projects that we are supporting in order to give access in Africa. But I can put you in touch with Titi, and she will be more than happy to give you more information.
Next question.
Can you hear me? Yeah, this is Luis Lucatero from the Mexican regulator. And my question is for Ian. Ian, you know, we hear a lot about data protection, but we haven't talked about something that is just as important as data protection. And somehow I feel that this is absent from the debates everywhere. And I would like to know if you're working on that. This is about managed democracy. What I mean by that is that companies like Facebook, Google, Amazon, and in Russia, Yandex, in China, Baidu, they have the possibility to do statistical correlation of massive groups of people of different ages, and where they can extract a lot of psychological parameters and cognitive responses to different stimuli that they may see on the network. Now the question is, with all this power, you have the possibility to make somebody win an election. You have the possibility to fine-tune the public opinion of people on different debates. And now the question is, who is protecting us against this?
That's a nice question, thank you. So I think 'twas ever thus, right? So broadcast media has always had the power to give a particular view of things, whether it's political or something else. I think what's more interesting about the internet stuff is what is seen as acceptable. So I don't know if people saw a couple of months ago, there was an internet dating site that had done 6 months of research on its users without any acceptance or knowledge of the users. And what they'd done is they split their users into two. And for one group of users, they'd used their matching algorithms and said, actually, yep, you are a great match for each other, you should go meet each other. For the other users, they'd done the exact opposite. They'd given the worst possible match to that group of users. And we're doing it to generate statistics. How many, and this came out, they announced it and said, look, here is the research we've done, and it turns out you're all idiots, you'll just go out with whoever we tell you to. The thing that was interesting for me was the public response, because the public response was, that's really funny, those people are silly. Not one, as far as I know, not one of those people left the service. So I think it's about, I mean, Marco mentioned it before, there is a large-scale trust between the citizen and these services, these big brands, that maybe they are acceptable, maybe they're not, who knows? But I think it's about understanding, having ways of talking to large populations and explaining to them what they're doing. And we find that very, very difficult. I mean, just going to the previous question, sorry, we've spent a lot of money in the UK on an education campaign to try and help people understand, you know, this is a phishing attack, please don't do this. We're using government websites to tell people to upgrade their damn browser. So if you go to one of the government websites, a government-owned property, with an old browser, you get a bar at the top that says, go and upgrade. Other companies could do that. Yeah, I think there's a big trust issue around what the brands stand for and what it actually means. I know that's not really answering your question, but I think it's the best I can do, I'm afraid.
We've got 2 questions, 4 minutes. Cordell.
Yes. I'd like to follow up on the last point there, and this question of what does the brand stand for. Some of these companies we're talking about now amass greater powers than governments. In fact, Richard has asked us to look at state surveillance and corporate surveillance separately, and I didn't think he meant that they were mutually exclusive. They're really not that discrete. I mean, governments have jurisdictional limitations that major global companies don't have. I think what is missing in the discussion about data privacy is actually not a new concept. It's a concept we need to revisit and strengthen, and that is conflict of interest and confluence of influence. Companies can't be everything. There is a great danger if you are a bank, at the same time you are you enter into agreements to service governments. You are a search engine. You're collecting my data. You're a potential advertising agency. Conflicts of interest must exist there. And even more serious is the confluence of influence. So I think we have to get back to asking whether at a point, based on what you choose to do, you are getting too powerful, and you have to take a decision about where you're going to play. I'm not picking on Google, but Google, for example, has an agreement with the Israeli government to improve the bureaucracy. I am accustomed to hearing that the Jamaican government is getting assistance from the British government and the US government to assist with improving bureaucracy. When I hear that private corporations that are very powerful collecting information about me is entering into an agreement with my government to make the bureaucracy more efficient, I begin to ask, are those agreements public, like treaties? And if they are not, should they not be made public? That to me is the best protection that I could ask for.
I think that's a comment rather than a question, Cordell. I thought it was extremely clear. So I'm going to go to the last question or comment from Robert Pepper, and then we must close. Thank you.
Thank you. This has been a great discussion on privacy, data protection, implications on human rights and the way it was set up. But we haven't had a conversation about cybersecurity. Given the nature of most of the cybersecurity threats, which, Ian, you just sort of began to just open up looking at phishing, for example, it's when systems are taken over. It's not in the transmission. It's for a variety of reasons. Individual end devices are taken over, whether it's a mobile or a laptop, in the enterprise, the corporation, the government. It's when systems are taken over, people get keys. Could you talk about the tension between cybersecurity and encryption? Because we talk about encryption to protect privacy, but the extent to which we have encryption, we can't see the bad stuff that's going on, and there's an inherent tension. So I don't know whether, it's Klaus, because this is an issue for you as an operator, because you actually see traffic, or whether it's Ian, but this is really important.
Right, Ian, I think, last word.
Okay, so encryption from an endpoint to a service only works if that endpoint has integrity. It hasn't been compromised by some malactor. And the thing for me is that the industry has fundamentally failed to address cybersecurity properly. And I'll give you an example about why that's the case. We've talked about incentives quite a lot. There is no incentive for technology companies to actually fix the underlying problem because it breaks their legacy. Right? So if you've got an Intel PC running Windows 95, the software you run on there will run on Windows 7, will run on Windows 8, and the guarantee that they provide is you can always get better, you can always roll forward. That drives a certain development type. So the biggest, the most prevalent exploit type on the internet is still a buffer overflow. Okay? We've had them for years and years and years. People like Microsoft and Google have invested huge amounts in putting education and tools out there excuse me, to developers to help them take these buffer overflows away. They're still there today. If I look at the National Vulnerability Database, there are about 7,000 vulnerabilities this year. right, that have been reported and have been patched. Of those, a significant percentage are still buffer overflows. The first public disclosure of a buffer overflow that I can find as a security problem is in 1974. So for 40 years, we have tolerated this. So we don't think the incentive model on development of technology actually works anymore. So what we've done is said, we've got a strategy called Secure by Default. It's been running for a few years, and it intends to do what it says on the tin, make stuff secure by default. So in 2012, we published a paper on the internet that says a secure platform, whether it's a phone, a PC, a laptop, a virtual machine, I don't care, should have these properties. There's 12 of them. Right? For us to go forward into this data-driven, really connected, hyper-connected world, we have to fundamentally change the security promises technology makes. And we think that's a first step. That has been accepted by pretty much every large company. Even Google have said that's a good set of things and we're going to do Chromebooks like that. Right? So as a set of principles to try and make security more acceptable, more accessible to people, that's a step. But in the end, it's about people making judgments. So I don't want to stop people clicking on a phishing campaign if that's what they want to do. If you think it's worth seeing the dancing pigs by giving away your entire identity, that's your choice. My job is to give you exceptionally high quality information so you can make that decision.
I'm afraid time is up. This excellent session. Can I draw your attention? In your pack, you have a copy of the Intermedia magazine, and there's an excellent article by Andy Hare on the area of big data, so I recommend that. It's printed on paper, and the younger ones present in the coffee, I'll explain what paper is. Magnus Brook from ITV doesn't know. So I think we've had a cracking morning. They've been marvellous, all five of them. Give them a round of applause.